Good afternoon. Welcome to our webinar series on China's new law economic governance. My name is Angela Zhang. I am Director of the Center for Chinese Law and Associate Professor at the University of Hong Kong. Our seminar today is on the China Initiative, which is a program launched by the US Department of Justice in 2018 that target at economic espionage emanating from China. As many of you have read in the news recently, Professor Chen Gang from MIT was arrested about 2 weeks ago by the US authority for improperly disclosing his connection with China when he applied for funding in the United States, and for his failure to disclose in his tax filings about his bank account in China. Professor Chen's arrest has sparked an outcry from the science community in the United States, with the MIT president and over 100 MIT professors signing petitions, calling the prosecution just vilifies what would be considered normal scientific and academic activities. But Professor Chen's arrest actually just represents one of the many cases that have been prosecuted under the China Initiative program. And today we are very fortunate to have Professor Margaret Louise from the Seton Hall University School of Law to talk about this very timely and important topic. And we are also joined by Professor David Law from our own law school, who will give comments on Professor Louise's presentation. Some of our friends and colleagues have also joined the panel, and then they might give comments and feedback after Professor Law and Professor Louise. And if you have any questions, do feel free to leave them in the chat box and we'll discuss them during the Q&A. So I will now leave the floor to Professor Louise.
Great, thanks so much. Thank you, Professor Zhang, and to the whole staff at the Center for Chinese Law, particularly Ms. Chan for helping with logistics. I'm really happy to be joining you. And in the same time zone, I'm in Taipei, and I'm used to doing these talks at strange hours of the night with the US. So I am also appreciative that we do have people signing on from the US, and particularly those who stayed up on the East Coast. Welcome, and I hope you have some coffee. I'm going to only speak for 20 minutes or so because I do think we're going to have a lot of people with questions. I certainly, when we planned this talk, we didn't know that it would coincide so soon after an indictment getting this much attention. So I do want to give some background on the China Initiative, but then say quite a bit about what the current case that's in the news, the Professor Chen, Gang Chen of MIT, says about the China Initiative more generally. I also, I do want to say that, obviously I, as far as I know, I don't have any ethnic or heritage background that leads me to China. And I'm always sensitive that these issues are really impacting people who are Chinese Americans or PRC nationals in the US. And I've spoken at length with those advocacy groups, and it's really startling how much really hate there is right now. I was excited to see that there are reports that as early as Tuesday, which is now here, but tomorrow in the US, that we're expecting President Biden to release some sort of presidential directive, unclear whether it will be an executive order or a memo, but addressing hate crimes against Asian Americans and bias and discrimination more generally. I would be delighted if ending the China Initiative was part of that directive, but I think that might be asking for a proverbial pony at this point. So to begin, as mentioned, the China Initiative began officially in November of 2018. At that point, it was Attorney General Jeff Sessions. It feels very long ago. He stood up and he announced that there was going to be this initiative titled the China Initiative by the Department of Justice in conjunction with other parts of the government, though. And it would be addressing, I'm going to use their terminology here, that it would be disrupting and deterring the wide range of national security threats posed by the policies and practices of the PRC government. Of course, there had been cases before that involved intellectual property theft by people and companies that were linked to the PRC. And I usually speak in terms of the PRC party state because, as anyone who does any work with China knows, there's the formal government, and then there's the large and complex Communist Party structure that is interlinked. And there's under economic espionage, which was the central focus at the beginning of the initiative. It's really about intellectual property that's intended to be given to, whether it actually is given to them or not, to some sort of beneficiary that is either a foreign government or an entity attached thereto, which in China is generally, I think, seen quite liberally, with a lot of academic and research institutions having ties to the party state. So Sessions stood up, he announced this sort of coalescing and enhancement of resources. He soon left the stage and Attorney General Barr came in. AG Barr ran with the concept, and we saw huge support for the China initiative through the rest of the Trump administration, both from Attorney General Barr, also from the FBI. Christopher Wray has spoken at length about the China initiative. It's hard to know exactly how large the initiative is because of a lack of transparency. We do know that the FBI has said they've had thousands of cases being investigated. Christopher Wray has famously said that a new case is opened every 10 hours that's connected to China. But I want to make clear that when we hear big numbers like that, what it tells me is that the US government is putting significant resources behind investigating ties to the PRC. It does not tell us whether there is an increase in any sort of criminal activity that actually is linked to the PRC. That's really hard to detect. So we don't know how much there's been an increase or not. Now, initially, we had this focus on sort of thieves and hackers, people who are stealing intellectual property, taking it over to China. What we've increasingly seen over the course of the China initiative is more and more focus on what my friend Rory Truex at Princeton calls compromising relationships. So these are times that people, particularly academics or researchers, perhaps not in an academic environment, have connections to the PRC. This could be under one of the talent programs, like the 1,000 Talents program, some other kind of arrangement where they have a part-time affiliation, and either they have not disclosed this affiliation on a federal grant form in the United States, commonly called grant fraud, or they've gotten money from these overseas entities, not disclosed them on their taxes or through other means. So wire fraud is another case we see a lot. Wire fraud is a charge that is quite broad. It has been criticized even before the China initiative for how much power it gives to prosecutors to criminalize behavior that is really a lack of disclosure. Perhaps some of these cases deserve to be handled in a criminal manner, but one of my big concerns with the China initiative is that it's taking behavior that perhaps should be subject to more administrative penalties or other lower punishments and elevating them to a crime which can literally get 20 years in prison. That's the upper end, but these are very severe punishments that are possible under these criminal statutes. And so we've seen this shift of trying to figure out, even if intellectual property has not been given or attempted to have been given to a PRC linked entity, but essentially that people have been primed to act as a conduit for that information. And this has also been dramatized in a series of FBI threat awareness films. Some of these predate the Trump administration, but the most recent one, called The Never Night Connection, which you can Google, it is filled, in my view, with a bunch of tropes of the slick PRC operative with a cell phone and a wad of cash, the retired US naval scientist who just wants to get a chance to get a trip to China and a couple $1,000. They even have the sexy bartender who's trying to get him to drink baijiu. So certainly, these are laden with all sorts of bias and stereotypes, which I don't think are appropriate for our government in trying to describe national security threats. So when I wrote this paper, this article, which is still forthcoming, it should be out soon, but some production delays with the pandemic, I titled it Criminalizing China, and the draft is up on SSRN. because I really wanted to look at the China initiative from the standards that the Department of Justice sets for itself. That first, there is a spirit of non-discrimination that is in the Justice Manual, the manual for federal prosecutors. And even if we can't prove that anyone is being prosecuted because they are ethnically Chinese or a PRC national, the implementation and framing of the China initiative is very clearly aimed at people who do have these characteristics of connections with China. And I don't think it solves the problem by saying that we have some people who are white who have been prosecuted, like Professor Lieber of Harvard. And even some of the people who are not ethnically Chinese, if you look at the press releases when they've been indicted, it'll say something like, who speaks fluent Chinese, as if that is a reason to be concerned. And even in Professor Chen's indictment, it makes very clear in about the second paragraph that he is a naturalized US citizen who was born in China. And I'll spare you all the quotes from Bill Barr and others during the Trump administration about the existential threat of communist China and the concern for the non-traditional collectors. Not every, of course, they'll say Chinese student or scientist in the US is acting as an operative essentially, but the language is very heavily biased towards a concern for how these people might be compromised because of their ties to China. I'm happy to talk about that more, and I go into length in the piece. But I also just look based on a criminal law theory. I am a criminal law professor, about why it's problematic, because first of all, if the goal is general deterrence, in short, that the government wants to stop people, perhaps people who haven't even begun to think about connections to PRC entities, from even thinking about it, because they too could end up as the next defendant. I think it's unclear to what extent that kind of deterrence is working. And I worry a lot about over-deterrence, that we are stifling the kind of innovation that the United States needs to be that leader in science and technology. And I've been on panels, for example, with Professor Chu, who is a Nobel Prize-winning physicist, and he himself has said that he's seen that chilling effect, and people being concerned that because of who they are and where they're from, that they're going to be under the microscope. And that really worries me about what sort of negative influence it could have on the US's competitiveness as we go forward. So with all that, let me talk a little bit for about maybe 10 minutes on the Professor Chen's case. And so this is the case. He's a professor of nanotechnology at MIT, and he was, the initial charges came out, I think it was January 14th, but the indictment, so the formal charging document issued by a grand jury, actually came out the same day that President Biden was inaugurated, which I think is an interesting coincidence. And when you look at the charges, he is not being charged with actually transmitting any intellectual property abroad. Instead, we have the charges as follows. It's 2 counts of wire fraud, 1 count of failing to file a foreign bank account report, and 1 count of making a false statement in a tax return. So it's this failing to disclose relationships. What was interesting, because we've seen a number of prosecutions, of course, under the China initiative, but here we saw a very swift response, first by his colleagues at MIT. They issued an open letter questioning the merits of the case in a very forceful manner. And we also saw a swift statement from the president of MIT. And he has spoken out before about the China initiative more generally, and concerns that researchers and students on their campus were being questioned by the FBI and more generally being subject to enhanced scrutiny. But here in his written statement, he said that he wrote in support of the Chinese and Chinese American community, and further added, quote, "We value your contributions as students, colleagues, teachers, innovators, and leaders, and we value you personally as friends, just as we value every member of the global family of MIT, including Professor Chen and his family." And so I think this has been really interesting to see how fast and coordinated and supportive the MIT community has been. And I think Professor Chen's case really highlights 2 major concerns with the China initiative. So we have an overemphasis on national security, and we have an underemphasis on bias. And what do I mean by that? And what we really need to think more, I think, as a country, and I say this as an American, that about how we define national security, and that there's been a tendency towards an over-securitization of the US-China relationship, that everything is a national security concern. And that has, again, chilling effects on people's ability to have engagement, although that's become a fraught word, so sometimes I say connectivity with China. And some of this comes up anecdotally, like students who won't go to China because they're afraid they won't get a security clearance down the line. When I first went to Beijing in 1995, that wasn't on my mind, but concerns that you will look compromised if you're in China. We've seen an ending of the Fulbright program in China, which is just stupid, because I've never seen anyone say you will compete better with someone by knowing less about them. But there's a general sense that what is considered national security has been growing. And here, using the criminal law to protect national security, there is a role for that. And it could well be that Professor Chen is guilty of these crimes because they're essentially disclosure crimes or lack of disclosure. They're not particularly difficult to violate. But I do think we need to think very carefully, when is it appropriate to use harsh criminal punishments for these kinds of violations, particularly when it is failure to disclose. There might be egregious examples where some sort of criminal punishment, including prison, is appropriate, but I worry about a ratcheting up, that we are over-relying on criminal law when administrative penalties could be better. And also we need to think more about how to do better training, such that people who are engaged in these kinds of research activities really understand what are the requirements. And as a professor who has been through a lot of trainings on things, it also requires emphasizing these are really important trainings, because some of them, there's a lot of forms involved. And so that's something which needs more emphasis as well. And we all, those of us who work in criminal justice, know that prosecutorial discretion is vast, and the tools that prosecutors have are powerful. And I think a lot of this too is going to be based on a shift in prosecutorial discretion. I'm very hopeful that under the Biden leadership, and hopefully soon to be AG Garland, that we are going to have a dramatic shift in messaging from the, at worst under the Trump administration, the China virus and that kind of vocabulary. But even if it didn't reach that extent, there was a lack of appreciation, turning to the bias side of the equation, there was a lack of at least overt appreciation for the role that bias plays in the work of prosecutors, and in particular, implicit bias. During the Trump administration, the people in the DOJ that were working on the China initiative said repeatedly that they were being sensitive to that there was a higher percentage of Asian Americans, Chinese Americans, and PRC nationals who were being turned into defendants under the initiative. However, they repeatedly asserted that they were just following the evidence and there was no bias involved. I do not believe that, because they are human beings. And what we know about implicit bias is that everyone has it. It's really hard to change. A few simple trainings aren't going to do the trick. And in fact, bad trainings can make things worse. But to fail to even grapple with the role of bias, I think is just not being realistic about how prosecutors and people in general go about doing their work. So the Biden administration has a lot of work to do with respect to thinking about how bias is feeding into their practices. That's partially with the China initiative. And of course, it's much broader. I teach US criminal procedure. We talk a lot about race because structural racism is also, of course, a huge problem when it comes to Black and brown people, not just people who are ethnically Chinese. So again, at a minimum, I think the Department of Justice of China initiative is problematic in its framing and implementation because it goes against the spirit of non-discrimination. And it's also just from the perspective of wanting to keep the US innovation very strong and competitive, are really not necessarily going to put the US in a better condition down the road. As far as what's happening right now, one interesting report that the Wall Street Journal had a few days ago was that the Department of Justice is kicking around the idea of some sort of amnesty program. Now, the word amnesty is not usually used by DOJ. Rather, they're going to speak in terms of some sort of voluntary self-disclosure program. You come forward, you voluntarily self-disclose that you've had contacts with some sort of foreign entity, and maybe you didn't disclose how much money you got from that entity. you have a bank account abroad that's connected with it. And if you come forward and disclose that there might be some sort of safe harbor that you won't be prosecuted. This has been done before, not a lot. There was an example, I think it was with Swiss bank accounts. More commonly, it's been with corporate defendants, not with individuals. It's difficult to craft these programs because you don't want to give a blanket free ride, no matter what you did, just tell us about it, all's good. But I do think that this would be a positive step if crafted carefully to give people a chance to disclose perhaps, something they didn't think was a big deal at a time. They kind of just, more the sort of administrative oversight than the real nefarious, I've got millions stuck away that I'm not telling you about. But it still will cause costs for the people who are disclosing, and it's not going to be a silver bullet. I think, too, the Department of Justice under Garland should take a good look at some of the ongoing prosecutions. For example, there's a case right now in the District of Kansas, Franklin Tao. It is going towards trial. He is actually defending himself against the charges. A lot of these cases plead out. There's been 2 superseding indictments, which is usually a sign that the evidence wasn't as strong as anticipated. I think that's a case that deserves a hard look and whether there should be some adjustment or dismissal of charges. And I also think more generally, there needs to be a total reevaluation of how criminal law is used to protect intellectual property and national security threats emanating from the PRC. And this needs to be bigger than DOJ. I was delighted to see that the science advisor has been elevated to a cabinet level, and we need that sort of buy-in from the scientific community to explain to us lawyers when is it open science that we need to let flourish in the sunlight, and when do we have national security concerns with IP. I think there also needs to be more participation from the communities that understand China better. I'm still not clear how those who are working on the China initiative have really learned about the structure of politics and government in the PRC, and also criminologists who can talk more about how deterrence really works and some of those theories. And so I'd love to see that. And just finally, I'd like to end with looking at when Jeff Sessions started the China initiative now over 2 years ago, one of the first things he said in his remarks at the press conference was he celebrated that, this is a direct quote, "For decades, the United States has led the world in science, technology, research, and development. Without a doubt, we are the world's top innovator." So yeah, and I think the initiative that he set in motion threatens to undermine that position as the world's top innovator. And so what I am hopeful for now that we have the Biden administration is that there will, of course, continue to be security concerns directed and linked to PRC, but I really want to see an overall strategy that promotes innovation and not incarceration. And with that, I look forward to hearing Professor Law's comments.
Thank you very much, Margaret, for your wonderful presentation. So David, would you like to give your feedback?
Yeah, sure. This is, and Maggie, the time discipline is fantastic. We could all, a lot of us at HKU can take draw a lesson from the time discipline there. So this is obviously, thanks for doing this. This is a thought-provoking paper that's bound to engender a lot of discussion, and I'm sure the audience will have a lot to say about it. It does raise a lot of questions, and so I think I'm going to try to pose some of those, or as many as I can in the time permitting. And I will start my timer. My assumption is that this is going to be a pretty sympathetic audience. So I'm going to try to kind of counter program against some of that, right? So 2 fundamental questions about the paper, right? First, what is the nature of the thing that you're objecting to? And why, right? Why is it objectionable, right? I think those are the 2 basic questions of the paper. And it shows that you've done multiple iterations of this paper. You've anticipated a lot of objections, qualified a lot of the claims, which is, I think, important, essential, and good. But that does raise the question, what claims are left after all those qualifications, and do they match the framing of the paper, right? There's a sort of a level of irony here in that we're objecting to the framing of the China initiative, but the objections to that framing itself may have some framing issues, right? So first, on the question of what is it that you're objecting to in this paper, right? What is the paper objecting to? So it's provocative framing. The China initiative is described as being, quote, at best in tension with foundational principles of the US justice system. But then we get deeper into the paper And there are no signs of illegality, certainly by the government. In fact, it's hard to even find signs of immorality. Instead, we have the concept of China-ness, which is a bit of a mystery, right? To the extent that I can summarize it, it's kind of like DOJ is doing a bunch of things that maybe perhaps are justified as matters of both law and policy, but their vocabulary is imprecise and hurtful because it employs a construct called China-ness that is derogatory. In the paper, what the article's arguing is that DOJ has framed the China initiative in a manner that expresses the government's conclusion that people with indicators of China-ness are an enhanced threat, and that message is being reiterated by people leading the initiative. So my initial reaction to that was, well, what the heck is China-ness, right? I know what anti-Chinese racism is. I've been on the receiving end of it, not as, having lived my entire life in North America, Canada, the US, not as much as the Chinese media is currently depicting happening to Chinese Americans. This is kind of the thing where someone that it happened to, but it doesn't quite happen to you directly. But mostly schoolyard stuff. But one thing that I've never had thrown at me is this idea of China-ness, right? So first, kind of what is this, right? It's bad, but it lacks intent. Is it a terminological thing? Is it sloppiness? What is it? Likewise, this idea of a Chinese versus American binary that depicts the threat. This threat is emanating from China. So you have here, just to pick the IP example, right? As the paper clearly explains, you have Chinese state-directed, organized, coordinated IP theft, right? But then we're not supposed to depict the problem as being China. So the analogy that comes to mind is, you're fighting fires and there's thick black smoke coming from the Johnson's house. There's these flames coming over from the Johnson's house, but you can't say the problem's coming from the Johnsons because that makes the Johnsons look bad, or it suggests that they're bad people. So then the question is, what are you supposed to do if you can't say that the problem is coming from the Johnson's house when it's coming from the Johnson's house? So that's kind of a ground road question. So that's on the what is it that you're objecting to in the paper. The second, why is it problematic? So I think there's kind of both a conceptual and a substantive issue here. On the conceptual front, this idea that we shouldn't bundle together acts of individual Chinese citizens or Chinese nationals into a quote unquote China threat. So I think that, you and I both, like a lot of people in this room, would love to divorce the Chinese people from the Chinese regime, right? I've done this in writing. I've encouraged the entire comparative common law listserv to never refer to China for political or legal reasons, and to refer only to the Chinese Communist Party because the word China gives the CCP a legitimacy it doesn't deserve, and tars the Chinese people with the brush of the CCP regime, which they never chose. But the problem here is the reason that that alignment occurs between the Chinese state, the Chinese regime, and the Chinese people is because the CCP itself does not want these things separated, right? We're dealing with a construct that is promoted by the regime itself. They can't exploit nationalism without latching onto the nation, so that's exactly what they do. So given that this is the CCP's move, the bundling of the Chinese people and the Chinese state and the Chinese nation, how do we demand that the US government or US politicians, even in their rhetoric, draw fine distinctions that the CCP itself makes a point of eliding, right? So, to kind of try to sum that up, the Chinese Communist Party makes a point of speaking and acting for China for reasons of legitimacy, internal. So then why is it wrong for those on the other side of the fence to use exactly the same construct? Isn't this just the CCP being hoisted on its own petard? Okay, so the substantive issue I had with the framing here was with the claim that this is in tension with fundamental principles of the US justice system. I was really on the edge of my seat. I was thinking, okay, so she's gonna show that the DOJ is factually wrong and or behaving illegally, or at least there's some unethical or immoral behavior, or at least it would be clear why the framing of the China initiative, right, it raises legal, moral issues. I don't know that it ever quite came, right? So I've tried to run through what the arguments were in the paper for why we should be so concerned about this. So one problem I see what the DOJ is doing is the terminology, right? There's a lot of oversimplification and sloppiness, right? English speakers are obligated to use, as you put it, more disciplined phrasing because the word Chinese is ambiguous in the English language in a way that it isn't necessarily in Mandarin, right? It could be ethnicity or it could be nationality. So basically, we don't like ambiguous verbal shorthand, but no lawyer does. But I don't know that that gets us close to anything resembling malice or misconduct, never mind tension with foundational principles of the legal justice system, right? As we know, right, as you reflect in the paper, DOJ is making an effort to frame things so as not to point a finger based on ethnicity. Right? We can talk about implicit bias, but as we both know, that's the everyday operation of the American criminal justice system, right? So, where is the implicit bias training with respect to Chinese defendants for DOJ? I don't know. I wish it were there, but maybe they've taken a number and they've gotten a line behind Black Americans and Latino community, right? So, that's a problem, but I don't know that it's a problem that relates to the criminalization of China, right? That's an inherent cognitive problem that all prosecutors everywhere are going to have, and the US is not immune to that, but it's also not specific to China-ness, right? But I think, again, a more fundamental reason why it's hard to distinguish nationality and ethnicity is, again, because this is a move that China itself doesn't want. See, there I went, right? It's a move that the Chinese regime itself doesn't want to make, right? We are familiar with countless stories of the Chinese government wanting to treat people as Chinese, even though legally, politically, they're not Chinese. They're ethnically Chinese, right? I have to worry about being treated as Chinese when I'm in China, even though I've done everything I can to make that difficult, to make that claim difficult. I don't even use a Chinese name, but I still have to worry about it. So, this is, again, the construct we're dealing with, but where does the construct come from in the first place? Does it really come from this, Jeff Sessions or the Trump administration? Okay, so some questions here to think about, right, that I think people could reasonably ask about the paper. You kind of want to think about what your answers are. You may already have answers for these, but, one is, do we object when people talk about China in a positive way, right? Even if it's descriptively inaccurate. China has great food. China has a long and glorious history. When and under what conditions is it possible, acceptable, in your view, to speak about China without triggering concerns about China-ness? Does this mean that we can only talk about China in a neutral or flattering way? What justifies prophylactic measures against uses of the concept of China in the prosecutorial context and not others? Right. Second question, you mentioned, I think on page 5, that criminal law is based on the premise that guilt is individual, not by association with entity. But as we also know, one of the main tools of federal prosecutors in dealing with any kind of large-scale criminal activity are the conspiracy laws, such as RICO, right? And then, so the question we face here, is this behavior occurring with state knowledge / supervision / coordination / blessing? The answer that you clearly answer, the question you clearly answer is yes. So if those things are actually there, as the paper acknowledges, then what are prosecutors allowed to do? Do we say that culpability is individual when a US attorney goes after the mafia and says you're part of an overall criminal enterprise? If the FBI mounts a campaign against right-wing extremists on the view that they are out to destabilize the US government, do we say that this is unfair and those acts of those individuals should be disaggregated? Don't those individuals have even less organization to them than, say, members of the Chinese Communist Party, who are sometimes literally acting at the direction of the Chinese Communist Party? So, a third, I have a number of these, so I'll send them to you offline because I think my time is up, but just 2 more if I can. We're being asked in this paper to disaggregate this China construct to be fair to China. So the question is this a problem specific to China, or do other countries disaggregate the United States construct in the same fashion? Can we reasonably expect them to do so? Or is just the nature of how we refer in nomenclature to collective actors, right? So for example, the Medellin v. Texas litigation, as you know, about the ICJ, right? The ICJ says the US needs to comply with the Vienna Convention, and the US says, don't pin Texas on the US. Did the US get to argue, oh, that's Texas, don't lump us all together, right? You can't talk about United States-ness. And I think most of the rest of it you kind of anticipate at some point in the paper. But I want to sort of pick out, you suggest there might be an equal protection violation, two other things. There might be an equal protection violation with visa bans, but the footnote doesn't give any evidence of a potential equal protection violation. And I think the more problematic part with this argument is that even if there is an equal protection violation, then how could any visa ban against China for any reason ever fail to violate equal protection? Because any visa ban on Chinese citizens will by definition fall upon people who are ethnically Chinese, right? It's not like a whole grouping of countries, like say by religion, where it's transnational, and then there's evidence of racial or religious animus on top of that. The Chinese are concentrated in China. The last thing I just want to pick out from relatively early in the paper, which sort of was a red flag for me, is you say that cases should be connected, quote, only where there is compelling reason to do so. Why, again, should this be the test, right? Would we, again, impose this test on, say, prosecution of right-wing extremists who think the election was stolen, right? If not, why would we give preferential treatment to the prosecution of Chinese nationals than we would to the prosecution of domestic terrorists, right? How, in principle, should these be treated differently? Okay, so I went a little over my time, but hopefully not too badly. Thanks for indulging me. But as I say, this is going to make a big splash. People are going to be talking about this. They're going to be raising a lot of questions, and I hope that if these aren't questions you've already heard, they're kind of on your radar now. But thank you again. Terrific paper, terrific presentation.
Thanks, David. I'm going to try to respond to a few of those if I could, and then we'll open it up. So first, with respect to the visa ban, my whole point of that footnote was to say this is not a constitutional law paper that's going outside of the zone of criminal prosecutions. That's my wheelhouse. That's where I am concerned. And I welcome the con law scholars and others to look at the broader implications of the Trump administration and their policy towards China. Second, just going to your ICJ example, well, in the International Court of Justice, China or the United States, the state is the party. And that's my point. So when we speak in terms of like a US-China trade deal, it totally makes sense to speak in terms of China because that is the entity in question. My concern is when you map on the national security concerns onto the world of individualized prosecutions, and guilt is individual. And the people who are being indicted, the people who are appearing in court, the people who are being punished, these are individual people. There's been a few corporate defendants involved, but we're really talking about to what extent should an individual's guilt be tied to a broader conception of China. And there has never been, at least no one's been able to show me, an equivalent of the China initiative, that's like the Russia initiative or the Mexico initiative or I don't know, the Canada initiative. It is unusual, if not unprecedented, for the Department of Justice to frame a criminal initiative, a coalescing, an enhancement, a focusing of resources, and to get messaging that even though there was not a sheer quota, you had public statements by people high up in DOJ saying, we hope to see each of the 94 US attorneys having a case under the China initiative. These are high intensity, take a lot of resources. So maybe not this year, maybe next year, but it was clearly a priority. It was messaged that if you're not finding these cases, are you really doing your job? And as far as, is it illegal? It's so hard to prove a selective prosecution claim. When I teach criminal procedure, the example that the book still has is Yik Wo, who is from the 1800s and was a subject of the Emperor of China. To prove a selective prosecution is nearly impossible. And in fact, Asian Americans Advancing Justice and some other organizations have filed amicus briefs trying to make that argument, and they're all losing. And they know they're going to lose because it's a losing argument, but they feel compelled to make the point that there is no doubt, and I've talked to people again and again, that there is a focusing on to some level, and we can't prove empirically how much, people who have connections to China. And the reason I use China-ness is that sometimes it is historical. You could have been born in the US, but you were, your family has Chinese heritage. Could be the passport you had, could be the passport you used to have, but this connection that is broader, or as I said, even flagging people's language abilities as something worthy to go in a short press release when it was not related directly to the charges. And even it reminds me, unfortunately, of some of the really negative parts of our history of prosecutions before the Trump administration. I'm in Taiwan. It makes me think of Wen Ho Lee. And he spent, he was a scientist, and he did have contact with, he was in the United States with groups that had come from the PRC, charged with serious spying allegations. He was actually Taiwanese. And not only was he Taiwanese, he was a Ben Shengran. His family had been in Taiwan far before the nationalists came over.
Right.
Yeah, but you look at the wording around it, and there is a long history and a lot of
the
work
one
that's
leaks
been
is,
done on this.
if I could ask you though, you raised this question, the ICJ, I'm really glad, I have to ask you, if you can't try China in the ICJ, and you're dealing with a state actor that has an MO that other state actors haven't had, and you have individuals acting at the direction of the Chinese state, and you can't try China for conspiracy in the ICJ, then what is the US supposed to do, given that this is a unique MO on the part of a state actor, to have individuals engaging in state-directed, state-encouraged IP theft? If you can't try China in the ICJ, you can't go after their conspiracy laws, what is the US supposed to do, given that the nature of the threat is not individual, but it is in fact collective? And it's a state actor acting through individuals.
Yeah, and the language, again, it does anthropomorphize China, because you'll hear the FBI talking about, that China steals, China cheats, China does these things, as if China itself has arms. And I stand by that. And as you said, well, China is the one, the PRC leadership is the one lumping people together. I personally, I don't care what other countries are doing. I'm going to hold the US to a higher standard because as a US lawyer, a US citizen, we should do better if there really is this belief in non-discrimination. And so I don't care what the PRC leadership is saying. And in fact, even I think that saying the Communist Party is bad is sweeping with too broad of a stroke. There's 90 million people, give or take, who are members of the CCP. And they vary in how much they actually are involved in the party apparatus. I'm unwilling to say all 90 million of them share equal responsibility for whatever Xi Jinping decides happened in Xinjiang or Hong Kong or anywhere. So yes, the US should have a strong, smart response to China hearing shorthand for the PRC party state. And that can be through sanctions, that can be through policies that are going to look at CFIUS and FIRMA and questions about investment in the US, questions about semiconductors. There's a reason that TSMC here in Taiwan is so popular in the US, because there's less security concerns than if semiconductors are coming from the PRC. That's all appropriate. But as long as the US is saying the Department of Justice job as prosecutors is to find individuals who are guilty of these crimes, and our job is not to secure prosecutions and eventually a conviction, but to do justice, I'm going to hold them to a high standard, that they're going to do that in a way that is not saying, well, China presents a particular threat in this moment in history, so if we sweep a few people extra in, that's fine. And that's not even the argument that was made by the DOJ under Trump. They said, we are doing this in a totally non-discriminatory manner. We're not sweeping with too broad of a brushstroke. This is not saying, well, normally we wouldn't do this, but we have to at this moment in history. That was not the argument coming. It was, we are being totally sensitive to these issues, and this is a completely appropriate use of our power. And I disagree with that.
That's great interaction. I like it a lot. Margaret, if I may ask you, take the opportunity to ask you one question. You mentioned earlier that now there is like an amnesty, potentially might be an amnesty program, and the Biden administration might take a different term. Maybe the China Initiative program might go into a different direction. What do you think we can potentially, what do you think the new administration can potentially do to unwind all this damage that have been done to the US-China relationship? I mean, particularly, this China Initiative program. Because if I put myself into the shoes of a scientist, a Chinese scientist working at the top US university, I mean, I'm not just thinking about what the Biden administration would do. I would think further along the road, what if the next president after Biden is Trump again, and what he will potentially do to me. So I think, I'm just wondering, have you and other scholars thought about, what could potentially, what the U.S. government would want to do about these things, and does it mean that from now on, not just companies need to take side, but people, scientists also need to take sides from different countries?
Yeah, and thanks. And I would disentangle my criticism of the China Initiative from U.S.-China relations writ large. And I've spent my career basically criticizing the PRC's human rights record, their criminal justice system. But of course, this is the one thing I do that China Daily suddenly quotes me favorably. I think that the Biden administration is smart to have a very strong response to the U.S.-China relationship. I don't agree with some sort of reset if that means means an immediate dialing back in tensions just to say, we are going to completely throw out everything that's happened during the Trump administration. There are reasons, and a lot of these emanate from Beijing, why the US-China relationship is so stressed. But I do think the Biden administration, specifically with respect to what the Department of Justice can do when it comes to its decisions, whom to prosecute and for what, there can be a massive change. As I said, there's huge prosecutorial discretion. So we need a couple of things. We need to have a real think about when it is appropriate to use the power of the criminal law for when there are disclosure violations. And this can be a change actually in the law. I doubt that would happen in Congress. So it's really a question about prosecutorial priorities. But at the same time, and this is where the longer term, post 4 years or post Biden administration is important, there needs to be that coordination with the science advisors and others who really understand the science and technology side of this, so that there can be a revamp of how the disclosure requirements are made, make sure those are as clear as possible, try to simplify and streamline across the different agencies such that if you are a researcher, it is as straightforward and clear as possible. Because what we want to do is find the people who are nefariously hiding away the ties and the cash, and not catch the people who either it's oversight, or just sort of maybe they just didn't take it as seriously as they thought it was. But a lot of that can be done by entities outside of the Department of Justice, and that would hopefully last far longer than a single administration.
Very good. Okay, so I would now open the floor for Q&A, and I will invite speakers on the panel to raise questions if you have any. And I already saw there are 2 questions from the audience. So if no questions for now from our panel speakers, I would raise this question from Shu Yu Chu. Thank you for the timely, insightful talk. My question is how to balance public order and human rights in time of crisis. What is happening now reminds me of 2001 terrorism attack. Both Islamic extremists and accused CCP sponsor spying, infiltration, espionage, and technology stealings are more than ordinary crimes, but so-called conflicts of civilizations, the fundamental threats to democracy and security of the US. Do you think this accounts provide some justification for the China initiative? The audience actually at one more point, the Chinese in part comes from the United Front policy apparatus and enormous funding and efforts the CCP is investing to use overseas Chinese to achieve their policy agenda, including but not limited to the accusations under China initiative. It is an organized, systematic, and long-term initiative on CCP's part. Maggie, would you like to respond to this comment?
Sure. Yeah. And I think this is so important to think about the continuum, because this idea of sort of united front and influence operations, and this could be concerns in the US that we have over Confucius Institutes, funding coming from the PRC government for language learning, but also cultural activities. And then it starts leading into talks of that might be political in nature. And this is all worthy of scrutiny. And certainly no place understands CCP influence operations better than Taiwan, where I'm sitting now. Like, this is a huge issue, both with the overt things like where you would have in the United States Confucius Institutes. Here it's more the covert and putting disinformation, fake news, and other ways of trying to undermine the government here. And those are all valid concerns. But again, I don't think that is distinct from what I'm speaking about, where you have the world of individual prosecutions. So we need to think of this on multiple fronts. There needs to be a push in the United States, which there is, to have greater transparency. Where is funding coming from? And when a university decides to take foreign funding, whether it be from a PRC-based entity or someplace else, what kinds of strings are attached, whether those be clear strings or otherwise influencing the nature of the programming that might be offered. We need to be thinking about, on the technology side, how to fight fight back against disinformation. Some of that, of course, is domestically homegrown in the US, but some of it's coming from foreign sources as well. And then we need to think about how are we using the criminal law in a way that is going to protect intellectual property, but also going to make it so we don't over-deter and have people afraid, essentially, of doing work in the US. And just more generally, I'd like to point out that if you talk to the IP scholars, and I need to put in a plug here for Mark Cohen at Berkeley, who's got a great China IP blog, that in general, there's a debate among IP scholars the extent to which criminal law should be used to protect intellectual property. And so with the Huawei charges, and some of those have been now criminal in the United States, one of the critiques, and I'm not an IP person, so I haven't taken a position on how much I agree with this, but that essentially some of the criminal charges are recycled charges from a civil case and in the past, and they shouldn't have been dealt with in a criminal manner. So that's a conversation that needs to occur as well. This fits to a more general conversation in the United States about over-criminalization and the extent to which there has been, this is a lot more use of federal criminal law in recent decades, and that has some benefits, but it also comes with costs, and we need to be clear about what trade-offs we're accepting.
Excellent. Do any of our panel speakers would like to raise any question at this point? Some of my colleagues?
I don't want to monopolize. I have got one, but take someone from the panel first.
We answered everything.
Too efficient.
Okay, David, go ahead.
So, okay, so this is a big picture question, right? And this is one that kind of slipped my mind as you were going through the paper. And this is a very good exchange because I think, it's an important exchange to have. One that doesn't anthropomorphize the China law community, right? Because there's some anthropomorphizing that could be done there. So let's just take the titling of it, right? The China Initiative. And let's take that, as the paper quite studiously, goes over it. Like there is a lot of evidence here of, the Chinese party state directing, coordinating, encouraging the acts of a lot of individuals who are engaged in, it's a terrible term, but let's call it economic espionage, right? It is coordinated. It's not random people acting randomly, just as a right-wing militia isn't. Although they may be kind of loose, clearly they mean nothing unless they act collectively for the most part, right? What would it take? Is there anything that Chinese nationals could do in the United States with the direction or supervision of China that would lead you to conclude that the framing of a China initiative as currently framed would be justified?
So so first of all, I think one of the concerns too is as soon as you call it the China initiative, then it is the blinders going that we're concerned about China. And so one of the cases under the China initiative, one of the actually there was a plea, was Dixon Yo, who was a Singaporean national, but he was convicted for he was trying to recruit people via, I think it was LinkedIn, but some sort of networking site to then be helpful in providing information back to Beijing, right? But he was a Singaporean national. He was outside of the PRC. So I think part of it too is that we all know that, it's not just that you have some hermetically sealed entity within the borders of the PRC, I mean, Xi Jinping and company, they're smart, right? So I think too, that we need to actually protect the US national security. The way better to go about it is to first to identify, again, what are the kind of assets that are real national security concern? And then we protect those assets from threats, no matter where those threats emanate from, because it won't necessarily all be as simplistic as saying, oh, well, you look Chinese, and so, or, you're connected to Beijing. And as far as at what point would we reach a status where I'd say, okay, well, we are just going to allow for mass suspicion based on people's passports. I know I never want to see the US reach that point, because I think at that point that we are, hearkening back to really bad times in our history of it's not the same as an internment camp of Japanese Americans, but it's certainly to say mass suspicion based on your nationality, your national heritage, your ethnicity would be so antithetical to everything that I hope we should continue to strive for, despite all of the challenges currently, that this is a country based largely on immigrants, and that we have a proud tradition, and we need to do better. So I refuse to set a bar at which point I would be okay with that.
I mean, let's use the mafia or the right-wing extremism examples again, right? Because we need to be consistent. We can't say, well, we don't want to undermine trust with China. We don't want to offend China. We don't want racism to fall on Chinese Americans. Let's take the Mexican mafia trials, right? I lived through those when I was in LA. I mean, there are two approaches to this. We can say, well, we're dealing with the Mexican mafia. And, frankly, Mexican Americans, they might face some blowback for that, right? Or we can say, well, we're just dealing with organized crime and money laundering, and we're not going to have an approach that's specific to Mexico. But the reality is that, the organizations you're dealing with are rooted in Mexico. They consist of Mexican nationals. If you were a judge or a prosecutor, you would recognize that these pose common issues of fact and law, and you would group them together, right? They would meet all the federal civil procedure requirements for having cases grouped together. I don't know that all these China cases would meet that particular requirement, but there's, I mean, this is, we're not setting any bar for what would justify the grouping of these cases, right? If even the standards in the federal rules of civil procedure won't do it, then aren't we dealing with something that is a real threat? It's not something you dispute in the paper, with kind of one hand tied behind our back. We refuse to actually label the problem for what it is, for where it's actually coming from.
So a couple of things. First of all, I have no problem offending Beijing. I think I hurt the feelings of 1.4 billion people. At least I've been told that I have multiple.
I'll race you.
So this is nothing to do with offending, Beijing.
Sure.
And as far as, one of the people I've worked with over the course of the last 2 years is Michael German, who's at the Brennan Center. And he was a former FBI agent. He left after 9/11 because he saw how the FBI was treating people who were they were Muslim, or their heritage led them back to countries that were seen as a particular security threat. He's written about it extensively. He's now working a lot on looking at the China initiative because of the parallels. And it didn't work out well for us, our response to 9/11 in a lot of ways, and how we othered and how we made populations that could have been so helpful in supporting our national security efforts and having language abilities and having cultural competencies and making them feel like they were under the microscope and othered and of concern. So I worry about that.
Argument.
And
you
so that's
part that in the paper. Like, you should bring that out. Like, if I know it's late in the process, but look, the 9/11 analogy is really interesting, and maybe I missed it on a quick read through, right? And I have objections to that too. But that's an interesting analogy, right? To problematize the national response to 9/11 and say, look, we understand that there's a quasi-state actor threat here, right? But what lessons can we draw from this? Then you're integrating, two bodies of literature in the same paper, and it's going to sound, I think, less like, again, to anthropomorphize the China law community venting over, these concerns they have, we're not being listened to, we're being mean to the Chinese. That's a different story. That's like, we've gone down this road before, and that was a mistake. And let me show you why.
And I know we're up to hour, but I just want to be so clear that I really don't think this is the China law community venting, and I know you're overstating it there. That especially having spoken with so many people who are in the communities, either they're Chinese, but especially those who are the scientists and the researchers, the level of, even those who have not been investigated, the level of concern and the stress that it's causing. And for those, even if eventually the charges are dropped, the physical, emotional, financial toll of being a suspect is immense. And so I never want to lose sight of, sometimes there's like, well, the charges were dropped or eventually found not guilty. But what did that person go through in that process? And those are real costs too. So, the last thing I want to do is diminish the experiences of people who have been wrapped up in this. So I think we're almost at the end, but I don't know if there's at least maybe one more question we can pull in.
Margaret, yes, we do. Nathan from Penn would like to chip in.
Hi, everyone. Sorry, it's pretty late over here, so I'm not going to turn on my camera, but it's so nice to see everyone. Maggie in Taiwan, David in Hong Kong, Angela. It's great to see you all. So I know it's late, and there's been so much that's been discussed that's so interesting, and this Gangchen case in particular is fascinating to so many of us. I think there's just one dimension of it that I would love to hear Maggie say a little bit more about. I'm so interested in the way that you talk about criminal law and about the individualization of criminal law, and how there's like a disconnect between that individualization and some of these like larger systemic things that we're thinking about. And as I've talked to some of my friends in the sciences, what I'm starting to get a very loose understanding of, just a glimmer of understanding, is that there's a lot of problems in science in terms of connectivity with foreign funding, with sort of disclosure requirements that are a little bit kind of messy. And yes, some of this, has a particular resonance vis-a-vis China, but it's, I think, a much broader problem than just China. There's a lot of different countries, a lot of different kinds of money that are floating around in the system. And so I just started to think, if that's the real problem, what's the best way to go about doing that? And is there, in fact, probably, a cost to making this so focused on China and so focused on the CCP and these particular individuals that we're sort of missing, in a way, I'm starting to think, are we missing the forest for the trees, where the forest is actually quite a big problem that needs a really systematic rethink on our side?
Thanks, Nathan. And this is why I was really excited to see the science advisor be elevated to a cabinet level position, and why I think it's so important that this not just be about the Department of Justice, that this is a much broader conversation that involves the scientific community, the National Institutes of Health, the big federal grant organizations, and really in this issue that open science has been so important to the US's innovation, but there are costs with openness. I know that, and again, I see that in Taiwan, that with transparency, with openness also comes some vulnerabilities. And what we need is a very honest conversation about what those trade-offs are. We need the right people at the table to think about that. And that has not occurred. And I fervently hope that the Biden administration will do that hard work, because it will be hard work to figure out how best to make it so we can go forward with really an honest appraisal of what we're willing to trade off and of the nature and scope of the threats that the United States faces, and clear policies that, again, I think rooted in a country neutral framing. That doesn't mean that we'll spend as much money looking for national security threats from Iceland as from China. I'm not saying that, but framing matters, and saying that this is bigger than just China. This makes a difference, instead of saying we are looking for the China cases, and that's having your starting point, that is going to shift your focus, and it's going to make a difference in the outcomes.
Excellent. I just saw my dean has just logged on at the very last minute. I don't know whether he forgot about the time, but unless Hualingham want to chip in, and I would think that we have perfectly concluded the talk at exactly 1 hour. And I want to thank Margaret, David, for the brilliant discussions, and for our audience actively participating. And I look forward to seeing you in our next webinar. And please follow us on social media. Okay. Have a great afternoon. Bye-bye, everybody.